So we use information that we receive regularly from those avenues into our risk engine. We keep track of media reporting and other sources of public information for matters that might be of some concern or raise doubts and questions, and feed that also into our risk assessment processes. And we work with other organisations, be they state revenue organisations or other bodies, as to if they encounter concerns around fundraising or other issues which might have relevance for us from a charity perspective.
So there's no proactive, if I could use the word, quality control in terms of whether charities are actually operating as charities. It's a reactive situation, really.
Well, proactive, I would say yes, in terms of a deliberate assessment of charities, particularly where one of the fundamentals of a charitable endorsement is to actually apply the resources they have to some charitable purpose. So we certainly monitor that there is apparent evidence of application towards charitable purpose.
What's apparent evidence?
Well,
I'm not a lawyer.
Well,
is that different from evidence?
Well, evidence that it might be that we can, we'll say an organisation that had no expenditure in a year in terms of the information they might report to us is obviously not expending it on charitable or any other purpose, which would of course raise questions immediately. So where someone does have expenditures, it's not known necessarily whether they're on charitable or non-charitable purposes, so the evidentiary level is somewhat weaker there. So there is certainly some proactive monitoring of the activities that we have from the information available to us. But if your sense of when we become aware from, say, a third-party source is where we may be more attuned to make an approach to a charity, but that's probably a fair observation in many cases as well.
The submission, the submission from Treasury, I'm sure you've had a look at the submission from Treasury. Were you part of, is this a joint submission, or is it simply a Treasury submission?
Well, we certainly provide some material and comments for them as they're drafting.
So I could take this as a submission that you could comment on?
Yes.
Yeah. The submission goes to the developments overseas, and I must say it's excellent. It's really helpful. Thanks for that. But it raises more questions than answers, in my mind. And one is that we seem to still be relying on 400 years of common law when other modern societies are moving to a different way of dealing with charities. Is there any lessons from what's happening overseas for us in your view?
Well, from an administration perspective, I guess if you look at those countries, particularly those of the British Isles that have shared a common legal history, they have generally moved to having a distinct charity or not-for-profit sector regulator separated from their taxation authority. I think that they still place great weight on the 400 years of charity law, because if you examine, just from my observations, some of the statutory arrangements they've introduced, they're often perhaps restating, maybe in more contemporary English and maybe with more precise, granular approaches, fairly much the historical four heads of charity, even if they're numbered up to 13 or 14, they largely cover, and I imagine you've had evidence that they largely cover the same sorts of things that are traditionally covered by the four heads of charity established 400 years ago.
So the overseas regulators are simply not regulators, are they? They're regulators, they're educators, and they're arbitrators, and they may do other things as well. So it's a far more broad-based approach to dealing with charities than we have in our that's the word, non-federal approach to it. Isn't it? It's far more sophisticated than we have in terms of an organisation. I'm not saying sophistication of the law, but sophistication as an organisation. We don't have an equivalent.
Well, no, as Mr. Wilcock pointed out, some of it relates to the legal and constitutional structures in other countries that don't have the same federal arrangement that we have. Countries that have a more federal arrangement, Canada, for example, has perhaps a similar structure to ourselves. Their charity regulation entity is within the revenue agency.
So do they do education?
I believe Canada do, as does the Australian Taxation Office, but basically in the absence of having a distinct charity regulator, of necessity to assist the sector to understand well what is required. We do undertake quite a bit of educational or advisory function to support the sector.
So one of the issues that, and I'm not hung up on this issue of federal versus the UK system. That can be fixed through COAG. So that's not an impossible position to deal with. So if we wanted to go down and take Senator Xenophon's bill a step further and move to a commission type structure, what would the implications be for the tax office in terms of your employees? Would some of your employees be in a position to move to a commission and provide advice and operate a commission effectively? And
well, on the presumption that the model of a charity regulator for Australia lifted some of the existing functions that are currently undertaken by the tax office to that regulator, yes, the tax office had less need for performing those functions. As to whether any particular staff would move, I imagine they would make their own choices, but I would imagine that the tax office would be prepared to offer whatever support it could to a new regulator with our experience and expertise gained to date.
Yeah, yeah, well, just one last question. The issue of independence from government in terms of the commission hasn't been said explicitly here, but I get the sort of feeling that there is a view that the taxation office is not sufficiently divorced from government to be truly independent. And I'm not making that assertion, but I get the feeling that there is a view there. And taxation is about revenue. Therefore, you know, your approach can't be truly independent because your focus is on revenue, government revenue. How do you respond to that?
I've certainly seen those disquiet in some submissions that there may be a perceived conflict of interest with the revenue agency having to determine charity status before it can look to the tax concessions, and that there might be a perceived conflict of interest about the revenue bias. That's perhaps different to independence from government. I guess any government body will have accountability to government, but the tax office, of course, is accountable to the Parliament as opposed to a minister. So it's a little bit different to some agencies, but I think my reading of some of the submissions was that the concern was that we would have a conflict of interest about granting charity status, recognising charity status, which might be seen to deplete the revenue base and therefore our revenue bias, as opposed to any governmental bias, I think was the way I read the submissions.
And I'll go to the Chair in a minute, but my last question at the moment is, with 65 employees, how can we be confident that the full range of monitoring, appropriate checks for new charities is being undertaken? Because it seems to me, for if we call it an industry worth between $1 billion and $8 billion, a monitoring organisation of 68 people seems to me to be minuscule. Maybe you want to think about that and come back, but I'm really interested in how it's done.